You know who else or what else I think has been hurt by this? It's the American Civil Liberties Union.
Yes.
Who sat and wrote that op-ed piece. I mean, after all, for all the testimony about that which happened, what the jury has found occurred and the like, to me, certainly, one of the striking background, but still significant aspects of this is that she didn't write this op-ed. She got help, a lot of help. She got drafting from the ACLU, who either was persuaded that she was telling the truth, and a jury has now said that is just wrong, or because of very major contributions that she'd made.
Yes.
Affected their judgment. Well, one way or the other, the 16th article about the case, and in my world, that matters because a lot of what I do has to do in one way or another with civil liberties, and their role, I think, in retrospect, will not be viewed well.
No, they don't stand for them anymore. They're not on the side of civil liberties.
Welcome back to another crappy legal usurpation, not to be confused with American Civil Liberties Union. See, here at another crappy legal usurpation, we just talk about people who give crappy or conduct crappy legal usurpations. We don't actually perform them ourselves. And if you just heard that gentleman right there, then you know what I'm talking about. The American Civil Liberties Union, they wrote the op-ed for Amber. They found the Washington Post. They helped her publish it. Shoot, they basically did all the work. I don't see why Johnny's not suing them for defamation. Seems a little strange to me. Anyways, here at another crappy legal usurpation, we're actually going to go through, we're going to watch the ACLU's testimony, and we're going to talk about it. We're going to see if they had a crappy legal usurpation, if they left a crappy legal usurpation on Johnny's bed. We're going to see exactly what they did. Stay tuned. We'll be right back.
Purportedly dated November 6, 2018. Who's Jerry Johnson?
Jerry Johnson was a more junior person in our communications department. His title was Communications Department Strategist. And strategists are often communications department associates that have expertise in and do work in a select number of our issue areas.
Okay, he writes, I'd like your and Amber's thoughts on doing an op-ed in which she discusses the ways in which survivors of gender-based violence have been made less safe under the Trump administration and how people can take action. Why was the ACLU recommending that Amber write on that subject?
With Amber agreeing to be an ambassador and to work on women's rights issues and in particular issues of gender-based violence, Jerry was coming up with specific things that were of significant policy importance to the ACLU that could be the subject matter of an op-ed written by Amber.
Directing your attention a few lines down, he uses the acronym GBV. What does that mean?
Gender-based violence.
Then further down, he says, if she feels comfortable, she can interweave her personal story, saying how painful it is as a GBV survivor to witness these setbacks. What is the ACLU referring to when it talks about her personal story?
There were a number of things that Amber had expressed from her personal story about her having been a survivor of gender-based violence And so one of the things that we do with ambassadors is we want them to tell authentic stories about our issues in the public, and to the extent that they have any personal direct experiences, for that to be part of their story for the public.
Now, I don't know about you, but this guy seems like he would be really annoying to have a conversation with. That's just my opinion. It's either that or he's really, really nervous. I couldn't see how somebody who misspeaks that much could really get a position like what he has. Obviously, this gentleman is not a trial attorney. You can tell that right off the bat. Let me think about it. Anyways, what did he say right there? He just admitted, yeah, the ACLU contacted Amber and said, hey, you want to write a piece? And presumably, they didn't know that she had made up her entire story at this point. Hopefully. I'm going to give them the benefit of the doubt on that one. That doesn't seem so bad. And they're like, hey, why don't you interweave your personal story? Like, what happened between you and Johnny in this? And honestly, at this point, I believe, I'm not 100% sure, but I think maybe, let me think about it. But I'm pretty sure Amber already had a non-disclosure agreement with Johnny Depp. So the greedy thing should have just been like, I can't do that. Sorry. And once again, I just wish to let everybody know that when they talk about an ACLU in here, they're not talking about us down here that like to report on another crappy legal usurpation. They are talking about the American Civil Liberties Union. Okay? Just wish to be really clear on that. Now, let's see what he has to say next. Yeah.
And Robin says to Jessica, your lawyers should review this for the way I skirted around talking about your marriage. Whose lawyers is she referring to there?
I believe these are Amber's regular advisors, or who were involved in the review negotiation of the NDA between Amber and Johnny Depp.
And then if you look at, direct your attention to the top email from Jessica White's to Amber Heard. She says to Amber, apologies for the delay, but we have needed to pass this through quite a few lawyers. What lawyers did Jessica White's pass the op-ed through?
These were lawyers in the Women's Rights Project of the ACLU, plus the director of the Center for Liberty, the deputy legal director of the ACLU, who runs the Center for Liberty, within which is the Women's Rights Project, and even the legal director of the ACLU, who runs the whole legal department, our programmatic litigation work on behalf of civil liberties, David Cole.
What were we talking about again? Oh, so he just testified. They wrote this. They even tell Amber. They tell her, they're like, you might want to run this by your attorneys. Because we kind of skirted around talking about Johnny Depp. So maybe you should run it by your attorneys, because we think possibly you could have some type of legal liability in this. So they told Amber to run it by her attorneys. And then they ran it by their own attorneys. Why didn't they run it by Johnny's attorneys? Did anybody think about calling them? Did anybody think about calling them and saying, hey, can you guys prove that Amber wasn't abused? because you're taking a pretty strong stance on it. You're already suing the Sun over in London. You got any evidence to back that up? I mean, all the other attorneys are involved, right? I mean, that's the way I think about it. Don't all those attorneys roll together? Aren't they all like getting along? Taking away our rights, our freedoms? I mean, this is the American Civil Liberties Union. What about Johnny's civil liberties? Doesn't he have civil liberties? Shouldn't they protect his civil liberties too? Well, I don't know. I just don't know. But let's see what happens next.
Employees, staff members in the development department regarding the placement of Amber's ad and the finalization of the op-ed piece. Not ad, I'm sorry, op-ed and the finalization of it.
This is December 11th email at 11:05 a.m.
Okay.
From Jessica Weeks. You see that? Okay. And she says, Amber sent back the op-ed with final edits from her legal team, which specifically neutered much of the copy regarding her marriage and the domestic violence. Do you see that?
I do.
Is that consistent with your recollection?
I'm not sure about the use of the term neutered here, but I do know that her lawyers removed references to her marriage and divorce.
And then she writes, the goal is to get this out this week to capitalize on the tremendous campaign for Aquaman. What does that mean?
That means, from the ACLU's perspective, that Amber is about to receive an incredible amount of press and be in the public eye. So what better a time would it be than now to put out this op-ed so that it generates significant readership about our issues?
And Amber agreed with the ACLU on that point, correct?
I believe the answer is yes. Every step of the way we were making these decisions with Amber's PR representatives involved.
I believe we were all acting like adults. And we got consent from all parties before we published this thing. But we did send it back to her and told her, well, we didn't send it back. My bad. She sent it back to the ACLU, not another crappy legal usurpation, but again, the American Civil Liberties Union. They sent the op-ed back to Amber Heard, and they said, this thing's neutered. And I can't believe this gentleman. He's really not that bright. What does neutered mean? Really? If we said we were gonna clip your nuts, would you know what neutered meant then? You gotta put all the juicy stuff in here if you want anybody to pick it up. And we gotta do this before your big movie comes out. Because you are ambassador. We promoting you to promote us. I mean, that's at least how I interpreted it. But, maybe I can't think right now. Let's, oh, you know what? You know what is really, really important? I almost forgot about it. And, I shouldn't do that. But he said it was an ad. The first thing he said is, we were looking for a good place to place the ad. Oops, not the ad. The op-ed, because op-ed and ad are just so similar that could be important later, but I don't know. Let's keep moving.
Okay, and finally, let's look at the beginning. The first email, Exhibit 41, from Stacy Sullivan to Jessica Weitz, says, yes, and I need to read the latest version, and Robin told me Amber's lawyers took out some of the stuff that made it really powerful. So let me look to see if I think it's strong enough for top tier. What did she mean by top tier?
I think from Stacy's perspective, the more powerful a document is, the more likely it will go into a top tier news outlet such as the New York Times or the Washington Post, you know, that sort of descending tiering that was in Jerry Johnson's email. Okay.
And is Exhibit 41 kept in the ordinary course of the ACLU's business?
Yes.
Was it? And she's announcing to the group that it's going to the Washington Post, a triple exclamation points.
Correct.
Take it the ACLU was pleased that it was placed in the Washington Post.
Correct.
And I believe you testified earlier, but I just want to confirm that for the record, the ACLU took on the responsibility of attempting to place the op-ed, correct?
Correct.
And why the ACLU instead of Amber or her PR team?
Placing op-eds about matters such as this is the kind of thing that is the bread and butter for the ACLU. And so I don't recall if a conversation happened about whether her PR people or our PR people should be in the ones that do the work to place this, but it is fully consistent with how we do our work that we placed this one.
We got the top tier, right? Yeah, because she put all the really good juicy dirt back in it that was all made up. You know, we didn't listen to the lawyers, we didn't listen to her lawyers, and we unneutered the piece. So we got it in a top tier position, the Washington Post. Great. And you guys got it in the Washington Post. The American Civil Liberties Union got it into the Washington Post. Well, yes, we did. Because that is our bread and butter. Bread and butter, right? See, Amber is having problems with her PR team. And the ACLU is like, we'll be your PR team for free. Because we get paid to be your PR team. That's funny. Who's paying them? Who's paying them to be Amber's PR team? What interest do they have in promoting this op-ed, in promoting somebody that a jury found to be incredibly not credible? A jury found that, I don't know if the jury actually found that she walked in and got a TRO and lied about the whole thing, but it sure does appear that way. If they didn't find that, I don't know why they made the judgment they made. But the op-ed, the ad that is the American Civil Liberties Union's bread and butter for some reason, somehow, some way. I don't know. I forgot. I'm just not good at this job. But if they're placing an ad and somebody's paying them to place that op-ed, that's where they get their bread and butter from. Who do you think is paying them? And what do you think they wish to see as results? Do you think they wish to see all Americans seeing very openly and blatantly that we have no courts of law because it took Johnny 6 years to find a court of law? It took 6 weeks to have the trial, and then it took 6 days for the verdict to come back. That's a little interesting, don't you think? Tad bit. This is apparently what the ACLU does. This is just what they do. It gets them their bread and butter. But what are they trying to fool you with? What are they trying to get you to think? Do they really stand for civil liberties anymore? I don't know.
Is this the online copy of the op-ed that the ACLU placed?
Yes.
Directing your attention to the title, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. Who came up with that title?
Based on my investigation, I'm not aware of I'm not aware that the ACLU had any role in writing the name of the op-ed piece. And my understanding of how op-ed pieces work is that it is the media, in this case, the Washington Post, would have drafted the name of the title of the op-ed and not the person who wrote the op-ed.
Did the Washington Post seek the ACLU's or Ms. Heard's approval of its title?
I believe the answer to that is no. There's nothing in the evidence that shows that they reached out to us to do that, and it is inconsistent with my understanding in that these news outlets do not usually ask for the permission of the author of the op-ed for when they come up with it.
I swear I couldn't talk to that man every day. So we got it placed, and the Washington Post, well, they're not team players. They don't know that they're working with consenting adults. They just made up the title all on their own. Who'd have thought? Who would have thought that they would make up the most sensationalized title that they could possibly imagine? Because that doesn't sound like newspapers to me. To me, that doesn't sound like the way news is sold. Would you buy that news? You know, I bet you would, because you probably just clicked on this for the thumbnail. Sea turtle. This is absolutely ridiculous. It's absurd. It's sickening. Because everybody I talk to on any side of the aisle, they're like, what she did was so bad. What she did was so awful. And you know what I think? I don't think what she did was nearly as bad as the fact that we live in a society that helped her, promoted her, got attorneys to write it for her, got attorneys to place it in the Washington Post, published it, and wrote a big, eye-popping, eye-catching headline for her. If this were a crime, I would call that aiding and abetting. I would call that an accessory before the fact. But what do I know? I just talk about crappy legal usurpations all the time. So I don't actually know what's going on because I'm not an actual attorney. I don't really feel like trading my life in to sell my fellow man's soul for a couple bucks. This is just bad. Does anybody else see how bad this is? Why don't we find out if somebody else sees how bad this is? Let's see if we can look on the internet and see if anybody else thinks that the American Civil Liberties Union has done some pretty questionable things. Maybe we can find a law professor talking about it. Let's check this out. This article out of The Atlantic. The ACLU has lost its way. It's written by Laura Bazelon. I don't know how to actually pronounce that last name, so my apologies if I'm mispronouncing it. A link to the article will be in the description below, but she talks about a couple of things because she talks about how the ACLU changed when Trump became president. And I thought that was pretty interesting, but I just wish to read these last two paragraphs because they're the ones that really, they're significant to what I'm talking about this afternoon. The ACLU now seems largely unable or unwilling to uphold its core values. To be fair, the organization still goes to bat for some causes that are associated with conservatives and free speech absolutionists, including the right to bear arms, of anti-Semites to protest, and of parochial schools to discriminate in hiring based on religion. And yet, since Trump's election, according to the New York Times, the organization's annual budget has grown threefold, and its lawyer staff has doubled. But only 4 of its attorneys specialize in free speech issues, a number that has not changed in a decade. Instead, the ACLU has expanded its service and filled its coffers, as it takes partisan stances or embraces dubious causes. Meanwhile, when it comes to the red-hot culture war issues squarely within its wheelhouse, such as the right to free, albeit hateful, speech on campus, the ACLU has stayed largely on the sidelines. Progressive causes are near and dear to my heart. I am a feminist and a staunch Democrat. As a federal public defender turned law professor, I have spent my career trying to make changes in a criminal legal system that is riven with racism and fundamentally unfair to those without status and financial resources. Yet, as someone who understands firsthand that the fundamental rights to free speech and due process exist only as long as competent lawyers are willing to vigorously defend extreme positions and people, I view the ACLU's hard left turn with alarm. It smacks of intolerance and choosing sides, precisely what a civil liberty organization designed to defend the Bill of Rights is meant to oppose. Well, after reading that article, I feel a little bit better. At least I feel like not all lawyers are, can't think, can't speak. It was very, very well written and very articulate. And this just goes to show this is not a left-right issue. She's a Democrat. And a very successful woman. And she's talking about their hard left turn. And earlier in that article, she talks about that turn was made around 2018 after Donald Trump was elected. The ACLU was talking about, with Donald Trump being in office, you want to talk about domestic violence, how his administration doesn't handle domestic violence well, something like that. Let's watch the clip.
I'd like your and Amber's thoughts on doing an op-ed in which she discusses the ways in which survivors of gender-based violence have been made less safe under the Trump administration and how people can take action.
This is pretty interesting. Now, what's even more interesting, in my opinion, I don't know, but the ACLU is trying to charge Johnny now, even after the jury came in and basically said, yeah, we think Amber made everything up. At least that's my interpretation. Don't come sue me, turd. But if you wish to, I'm right here. I love it when people sue me. Go ask somebody. I don't bring any crappy legal usurpations to court. So the ACLU does have another crappy legal usurpation against Johnny Depp. They are trying to charge him $86,000 in legal fees for testifying. They are billing him close to $800 an hour for a total of 30 grand. So within a week's worth of work, somebody over at the ACLU is billing him a whole year's salary for somebody. Yep. And in 2 weeks worth of work, another salary for a junior associate. They're billing at $500 an hour for $39,000 total. And then you have litigation support manager, 17.1 hours, $5,000, almost $6,000, $5,700. And these are court documents. This is what they actually filed, their bill. And let's see how Johnny Depp's legal team responded. In a response filed on June 1, 2022, Depp's legal team says the request is not only exorbitant and unreasonable, but unsupported by New York law. Depp's lawyers go on to say that he does not oppose reimbursing the ACLU for reasonable expenses, but they are seeking reimbursement for expenses that go far beyond what was reasonably required to comply with the subpoena. Quite simply, New York is clear that Mr. Depp is not required to reimburse respondents for the attorney fees associated with the time determining what documents to withhold from the production based on privilege or relevancy, the response says. Indeed, even if Mr. Depp were responsible for these expenses under New York law, which he is not, the fees incurred for these tasks are unreasonable and should be substantially reduced. For these reasons and the reasons set forth herein, the court should deny the respondent's motions. Well, you know, that's good and all, but this is just a verify website. To me, that kind of sounds like a fact checker. So let's go see what the actual court documents say, shall we? Respondents are seeking reimbursement for time spent reviewing documents for privilege, implicating privilege redactions, and preparing a legal log. But much of the time appears to have been spent improperly withholding, redacting, and or logging communications between respondents' counsel and Ms. Heard's counsels that are not privileged. Huh? What? You mean Johnny Depp, they're trying to charge Johnny Depp because they told Amber to take it to her attorneys, and then they took it to their attorneys, and they're trying to put those bills on Johnny? That seems a little weird. Mr. Depp should not be required to foot the bill for the time and fees associated with respondents improperly withholding material responsive to the subpoenas as privileged. You mean they didn't even give them everything because they said these are privileged? What? Why is this not criminal? Why is this not criminal? Oh, because even though the public can get justice for Johnny, we still don't care about justice for everybody. Which means we don't have courts of law. We don't have any real rights or real justice. That's why this is going on. This is why they can basically destroy Johnny's person, his mega pint superstar person in Hollywood, with another crappy legal usurpation, not to be confused with American Civil Liberties Union. Just to be clear, We only talk about legal usurpations here, crappy legal usurpations. We don't actually perform them. Just to be clear. This should be criminal. It should be. But nobody cares about justice for everybody. Only justice for Johnny. Because the rest of us are screwed. Because Johnny took this case to court after 6 years, and then he had a 6-week trial, and then the verdict came back after 6 days. That's not due process. That's not a fast and speedy trial. And why do you think he never got arrested? I mean, these are some really, really serious allegations. They are downright criminal. Sexual assault, violations like that, bottle. Yeah, you should get arrested if you did those things, but there wasn't any supporting evidence. And if they actually arrested him, it wouldn't be like family court, the administrative process where a judge could just decide. A judge could just decide. A judge decided. No, here in America, we gotta have a jury. Because we don't trust government. It's really that simple. And then if you go down here, of course, you'll see this is definitely, I mean, that's his most famous attorney. And then this guy, he's smart. He's really good. And he doesn't say, what was I talking about again? And you would think that this was bad. You would think that this was bad. But let's see if anybody else is talking about the ACLU. Let's see if any other news organizations are kind of bringing what the ACLU is doing in the opinion from the law school professor about the ACLU. She said something about 2018. So let's see what the ACLU was doing in 2018, and if anybody was writing about it or reporting on it. Sounds like news to me. The most controversial changes concerns what happens when a student stands accused of sexual misbehavior. Under the new rules, schools would be required to hold live hearings and would no longer rely on a so-called single investigator model, the New York Times reports. Accusers and students accused of sexual assault must be allowed to cross-examine each other through an advisor or lawyer. The rules require that the live hearing be conducted by a neutral decision maker and conducted with the presumption of innocence. Both parties would have equal access to all the evidence that school investigators use to determine facts of the case and a chance to appeal the decision. What's more, colleges will now have the option to choose a somewhat higher evidentiary standard requiring clear and convincing evidence rather than a preponderance of the evidence in order to establish someone's guilt. The ACLU doesn't object to any of those due process protections when a person faces criminal charges. Indeed, it favors an even higher burden of proof, beyond a reasonable doubt, to find an individual guilty. But the ACLU opposes the new rules for campuses. Today, Secretary DeVos proposed a rule that would tip the scales against those who raise their voices. We strongly oppose it, the organization stated on Twitter. The proposed rule would make schools less safe for survivors of sexual assault and harassment when there is already alarming high rates of campus sexual assaults and harassment that go unreported. It promotes an unfair process, inappropriately favoring the accused and letting schools ignore their responsibilities under Title IX to respond promptly and fairly to complaints of sexual violence. We will continue to support survivors. Under the old rules, a single campus administrator could investigate the claims, bring charges against the accused, and decide at the end of the process whether or not he is guilty. The accused could be denied the ability to review evidence against him. Exculpatory evidence could be withheld from him. He would not be able to cross-examine his accuser, and if the investigator decided there was at least a 51% chance of his guilt, he could be expelled. Under the new rules, an investigator must present what she finds to a neutral party. The accused can view the evidence against him, is told about exculpatory evidence, and gets to cross-examine the accuser through a representative. He may be declared guilty if there is clear and convincing evidence, not based on a slightly more likely than not standard. The ACLU believes that the latter scenario is less fair. Its staffers weighed what most meaningfully excludes someone from equal treatment in education, and they decided new due process protections are more problematic than expelling someone after a process wherein they were unable to see evidence or question their accuser or be judged by a neutral party. When someone stands accused of sexual assault in criminal court, does the ACLU believe in the beyond a reasonable doubt standard merely because that is what the Constitution requires, or because it is better to leave some guilty people unpunished than to punish many innocents? The old school ACLU knew there was no contradiction between defending due process and supporting survivors. David French writes, "Indeed, it was through healthy processes that we not only determined whether a person had been victimized, but also prevented the accused from being a survivor of a profound injustice." Joe Kennedy III, "No survivor should be cross-examined by his or her accused rapist, ever, full stop." A new rule from Devos would require universities to allow accused sexual abusers to cross-examine and re-traumatize their victims. This is absolutely sickening. WashingtonPost.com. Wow. You know what I took from that article? I took that the ACLU is basically promoting this administrative court process, trying to say it's not fair for people to get an actual court of law. We got to have trumped up, no pun intended, administrative processes where people can't get any justice. They can't cross-examine their accuser. They can't see the evidence. Lord forbid they ask a question. Lord forbid that the only other individual who has firsthand knowledge of what actually happens is allowed to say anything. I wonder how much bread and butter they got for that one. I wonder how much bread and butter they got for taking the position that we should just believe all women back in 2018, and that people accused of doing heinous acts like rape, they shouldn't have the right to due process of law or any due process of any kind. As long as we're not throwing them in jail, as long as we are just kicking them out of college and ruining the rest of their life and turning everybody in their life against them, you know, we're not putting them in prison, so you shouldn't have to afford them due process of law. I mean, we already did it to Johnny. We already did it to Johnny. Now, the last thing I kind of like to talk about is they keep on saying that Amber Heard is an ambassador for the American Civil Liberties Union. It doesn't sound like they have a whole lot of civil liberty ideas, but they are not to be confused with another crappy legal usurpation. That's just us right here, just conspiracy. But let's see what the American Civil Liberties Union, what their qualifications for an ambassador are. I'm really, really interested in this one. Let's watch.
I asked Ms. Weitz whether it was her decision to ask Ms. Hurd to be an ACLU ambassador, and she indicated that it was. I asked Ms. Weitz to describe what are the criteria for, sorry, a calendar thing popped up. What are the criteria for asking for becoming an ACLU ambassador? And what were the reasons why she thought that Ms. Hurd would be an appropriate ACLU ambassador?
How did Ms. Weitz respond?
She said that ACLU ambassadors are people who are artists or influencers that are aligned with one or two ACLU policy issues. And the criteria for determining whether somebody can be an ambassador is that they have prior expertise in that policy area, that they can speak in detail about the area, that they are aligned with the ACLU's policy views of the area, and that they have significant following so that their communications to the public that we support reach a wide variety of people.
Of those criteria, which did Ms. Weitz identify as the most important, if any?
I don't think there's any that she did not identify any as the most important.
What, if anything, did Ms. Weitz tell you about Ms. Hurd's expertise in women's rights?
Ms. Weitz said that she had arranged a meeting between Ms. Hurd and representatives of our Women's Rights Project and our Reproductive Freedom Project, and Ms. Hurd spoke with such clarity and expertise on issues of gender-based violence that she decided that she would be an appropriate person to ask to become an ACLU ambassador, and she did so.
She spoke with such authority on reproductive rights and gender-based violence because her testimony was so credible to all of us here in the United States, especially the jury. She spoke with that much authority that we said, we gotta have her as an ACLU ambassador. Now, as of today, and it's June 13th, it's almost 2 weeks after the trial. Here is the ACLU's website. These are the ambassadors for the ACLU. Amber Heard serves as an ACLU ambassador for women's rights with a focus on gender-based violence. Really? Still? And let's go down here and see what it talks about down here. Down here at the bottom it says, Heard contributed to the Washington Post in a moving 2018 op-ed calling for a change to the repressive stigma facing victims of sexual assault. You guys still got that up there? Really? Moving? You guys are really, really fond of your own work, aren't y'all? Because maybe I'm just a dummy that works at a no-name channel like Just Conspiracy, where we just like to talk about another crappy legal usurpation all the time. But if I were y'all, I might think about taking that down, maybe. And so, learn more about women's rights with Amber Heard. Well, she's so authoritative on domestic abuse. Let's see how much authority, let's see how much she knows about reproductive rights. Let's check this out. I'm just going to do a quick Google search, and we'll see what we come up with. Amber Heard welcomes a baby girl with the help of surrogacy. What? So she's fighting for the right for other people to have her children? Is that it? Is that what I'm to take from it? For real? Hey, why don't you just have a baby and then I'm going to take it away from you because I'm rich and everybody believes everything I say until I get in front of a jury. And this is one of the big problems. This is a huge, huge problem. Because the ACLU has a propaganda machine that fully backed Amber Heard. Articles were written by multiple people talking about how we should believe her. Even if she's lying, we should believe her. Why don't you just go ahead and say, we don't care about truth and justice? Why don't you just go ahead and say, we don't care about your freedoms. We don't care about due process, and we don't care about an actual court of law. And if an organization like the American Civil Liberties Union does not care about your right to access a court of law, who do you think is going to care on your behalf? Do you think that when your number gets pulled, when your ticket comes up and you go down to court, they're going to be like, oh, look, it's JC Duck. We got to have a court of law now. You're just going to have to wait 6 years and then have a trial for 6 weeks and then wait for the jury to come back with their verdict in 6 days. You think that's magically going to happen to you? Really? Because we're just so good at upholding the law. Because if the American Civil Liberties Union really cared about civil liberties, really cared about rights, then they would be making a push for domestic violence situations, or when people are accused of domestic violence in family court, or even better yet, what about you just bring a court of law into a family court? Why don't you just get rid of the administrative family courts and argue for getting rid of the administrative family courts and returning back to a court of law where a jury gets to decide who gets what and what the law is, kind of like they did for Johnny Depp and Amber Heard. But I guess that's not where your bread and butter comes from, because all of us out here fighting to try and get a court of law back for the rest of you people, we don't get any money. We don't get anything. It's not financially viable to us to do what we're doing, because the system as a whole does not want you to have a court of law. They want to make you believe you should believe Amber even when everybody knows she's lying. And they have a lot invested in it. A whole lot. Justice for Johnny really means we don't care if the rest of us get justice. We don't care if the rest of us have our rights upheld. And until we, as a society, until we, as a people, until we, as Americans, start to care about that, we're going to have people like Amber Turd stealing our children. And I don't mean that literally. I'm just making a pun because of the surrogacy. But honestly, the government takes children from people every single day without giving them a court of law, without giving them a jury. They actually have more rights as a criminal defendant than they do when the government is coming after their children. Think about that. Think about it. The future of your children is in your hands right now. We are just conspiracy and we just wish to bring heaven down to earth. If you can get down with that, come join the conspiracy. One world, love, and peace.